All right, well, let's talk about federalism. This is chapter 3. Recently, we have heard a lot of questions, arguments about how much power government should have and what different levels of government should be doing. And so really this chapter is about that very thing, about the different levels of government and how they operate in this federal system, where the United States is the first ever federal system that had equally powerful lower levels of government and a fully functioning powerful central government as well. So this is getting a little long in the tooth, but this particular poll was taken between 2009 and 2015, and the question was, do you believe that federal government has too much power? And at the time, 81% of the people that identified themselves as Republicans said that the federal government had too much power. Only 31% of the people that identified themselves as Democrats thought that government had too much power. And so, what does that really mean? We certainly hear a lot of people talking about small government, about rolling back government. And I think that is all well and good. And notice that I said I think. So we're about to get some Madelyn opinion in here. In the grand scheme of things, if our government is not able to meet our basic needs, then what is it there for? What did we give our liberty up for if our government is not able to help us in time of crisis? If our government is not able to give us a safety net that keeps us from hitting the ground when things go awry? This is a picture of Patrick Henry. If you'll recall from chapter 2, Patrick Henry was one of the founders of the Sons of Liberty along with Samuel Adams. And Patrick Henry was an ardent anti-federalist, and he argued actually against ratification of the Constitution, and he really thought that federal government, a central government, just should not have too much power. There were a few choices that the founders had when they decided what government was going to look like. Certainly, they could have chosen a unitary system like the one in Great Britain, where the national government, the central government, is sovereign. Anytime you see these words in bold, these are excellent quiz questions because they are basic definitions. You should, as you are studying, go to the end of the chapter, gather all the vocabulary words, figure out why they put those in bold, why did they put those in, and make sure that you understand all of the terms that explain what the meat of what's in the chapter. Just a bit of advice as I go back to talking about a unitary system. This means of determining who is sovereign, who has the power, who has the final governing authority. And in a unitary system, that's going to be the central government or the national government. In a confederacy, like what we had under the Articles of Confederation, that is one, and if you get that picture picture of the Articles of Confederation, the central government really had no power. The only power that it had was that was given to it by the lower levels of government. There was really, literally no one in charge, and therein lies the problem. Confederacies don't work. Now, where have we heard that word before? The Confederate States of America, when the southern states seceded. Maybe the European Union is a loose, where you have different countries and they agree to work together, but they are not giving up any of their power. So those are two examples. In general, confederacies don't work. There's chaos because no one's in charge. But what they settled on was this hybrid form of government where the states had power. They retained power. Each of our states has laws and they have constitutions and they have entire sets of government and elected officials, and our federal government does too. And both share the power. The sovereignty, governing authority is shared. And so that means that you're definitely going to have to meet out. You're going to have to decide who does what and decide what happens if there's a conflict. And that is all written very clearly in the United States Constitution. So, what are some of the things that you encounter if you are talking about federalism? What are some of the arguments that they had for drafting the new Constitution after the Articles of Confederation didn't work? Well, one, if you don't have anyone in charge, there is a more of a likelihood that there is no way to address public disorder, economic chaos, and that you won't be able to properly defend yourself. And we saw that in all kinds of examples, in the way to meet Shays' rebellion, when states went to war with each other, when states had different currency and wouldn't trade with each other. Those were all examples of the problems that come from having a national government that's too weak. So as they were drafting the Constitution, and one would argue that it was quite reactionary, that they were really addressing the issues of the day when they decided to write that Constitution. So they knew that they were going to have to write into this Constitution something that gave some power to the government, some moderate power to the central government, but there was no way that they were going to be able to not protect liberty. So by having two levels of government and deciding who is going to do what, you give yourself an opportunity to have a functioning federal government. Two different layers of government, both with power. So let's look at the United States Constitution, shall we? I have first gone to Article 1, Section 8. So there are, if you will recall, 7 articles in the Constitution. The first article addresses the Congress, this large chamber that was designed to have the most power. Article 1 is by far the longest part of the Constitution. And in it, they laid out the powers of Congress. They explained how representatives would be elected, how senators would be elected, how they would address vacancies. But they got to Article 1, Section 8. And if you're listening to me, I want you to say it out loud. Say Article 1, Section 8. Because here is the heart. This is the heart, in my opinion, of the United States Constitution. Here is where they laid out 17 express powers of Congress. And they are huge. Now, they started with the most important one of the big glaring issues with the Articles of Confederation was that they were not able to collect taxes. And so the federal government ended up running out of money. The first power that they granted to the United States Congress was the power to lay and collect taxes. Number one. Then they went on to say that they could borrow money. They gave them the power to regulate commerce, and put a pin in that. That's going to come up over and over and over again. But the power to regulate commerce, not only with foreign nations, but among the states and with Indian tribes. And again, the tribes were viewed as separate nations, and so they did treaties with members of tribes, with the leaders of tribes. They also gave them the power to decide who could become citizens and under what circumstances, to decide bankruptcy. They gave them the power to coin money. They gave them the power to provide for the punishment of counterfeiting, establish post offices, promote the progress of science and useful arts, which is patents and copyrights. They gave them the power to constitute tribunals inferior to the Supreme Court. They gave them the power to punish piracies and felonies on the high seas, the exclusive power to declare war, to raise and support armies, to raise and provide and maintain a navy, to make rules for the regulation of the naval forces, calling forth militias. These were the state military bodies to execute the laws of the Union and suppress insurrections and repel invasions. Finally, they were given the power to exercise laws within the District of Columbia. Now notice Clause 18. Clause 18 says that they have the power to make any laws that are necessary and proper to ensure that the foregoing, those 17 powers, can actually be put into law. They have the power to pass any law to regulate commerce, to collect taxes, for the Army, for the Navy, for naturalization, for bankruptcies. All those things that are listed, they have the power to do, including regulating commerce. So they can pass the laws to make them happen. We sometimes call this the necessary and proper clause. Another term for it is the elastic clause, because it expands out to give Congress a lot more power, because they can pass any law to make any of those powers that have been enumerated actually work. They also gave. So let's look at some other parts of the Constitution. So we have looked at Article 1, Section 8, and the 17 powers that are listed there for the United States Congress, the most powerful branch of government. We looked at the necessary and proper clause, which is Clause 18, that expands the power of Congress to make laws to put into action their 17 enumerated powers. We looked at Article 1, Section 10, that outlines what states cannot do. Now let's look at Article 4. Article 4 of the Constitution. So Article 4 outlines states' responsibility to each other. There are some things that states have to do as part of the United States of America to make things move smoothly for all citizens in the country, for all people that are in the country. One of the things that states are required to do is to give full faith and credit, meaning that all of the laws, the acts, and judicial proceedings of a particular state, you have to recognize that. If somebody was married in Hawaii, they moved to Texas, then they are still married. You recognize that they were legally married in Hawaii. If someone got a judgment in Kentucky and they moved to Arkansas and they wanted to enforce it, they could go to the Arkansas court, record that judgment, and the Arkansas law enforcement would help them to enforce the judgment. That's on the civil side. Another thing on the civil side that they are required to do is give the privileges and immunities to anyone, regardless of what state they are in. They are to extend the privileges and immunities of living in your state to everyone that comes into your state. You cannot distinguish between someone that lives out of state and have special laws that only apply to people that live in your state. Another thing that they are required to do is extradite. If somebody is found in your state and they have a warrant for their arrest in another state with treason, felony, or other crime, then you are obligated to hold that person and deliver them to the state if the state asks you to do so. You cannot hold them. You can't say, well, y'all have the death penalty, so I don't want to send them back. You don't have any choice within the states. So those are the primary issues that we see that require states to work together, not fight each other, and not discriminate against people that are from other states. All right, let's look at Article 6. Article 6 is sometimes called the Supremacy Clause. Sometimes called the Supremacy Clause. So one of the things that they did was said specifically if there were any debts that had been collected, they would be valid against the United States under this Constitution. But the biggie in Article 6 is Clause 2. It's so big that I'm going to read it. I know you can read, but I'm going to read it myself. It says, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authorities of the United States, shall be the supreme law of the land. This Constitution, the laws, and any treaties of the United States will be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So if there is a conflict between federal law and state law. Article 6, Clause 2 says federal law wins every time. It's in the Constitution. Federal law wins, the federal Constitution wins, federal treaties win if there's a conflict. But I have to introduce you to another Madelynism, and that is a law is not unconstitutional until Supreme Court says it's unconstitutional. That's the way that we determine that there has been a violation of the Supremacy Clause. So the federal government does not just walk around looking at state laws and saying, well, that's contrary, so you can't do that, and that's contrary, you can't do that. They have to, a matter has to go through the court system. It has to be justiciable, simply meaning that it has to be something where there is a cause of action and there is a problem that needs to be addressed, a question about whether or not the law has been followed, and then it has to make it all the way to the Supreme Court. So let me give you an example of what I mean. Now this is a map. And the particular law that we are going to look at is marijuana, the use of marijuana and legalization of marijuana. So notice that they have color-coded the map. So those that are dark, so this is Oregon, Washington, California, Nevada, Hawaii, and Alaska, Colorado, Illinois, Michigan, Vermont, Maine, and Massachusetts, and the District of Columbia. I like to say them all. Those are the ones where recreational use of marijuana and medical use of marijuana are legal. You don't have to have a prescription. You can just walk up to a dispensary and purchase small amounts of marijuana if you are age 21. The states that are in dark green allow medical marijuana and have really decriminalized possession of marijuana. The lighter greens allow medical marijuana, but not recreational marijuana, and have not decriminalized the possession of marijuana without a prescription. So then and notice that Texas, they have listed as mixed. Now, Texas has not decriminalized the possession of marijuana. CBD oil can be purchased, and cannabis oil can be distributed to young children that have severe epilepsy, but not to anyone. No one else is going to be able to get a prescription, and there are only 5 locations where the state of Texas has designated that dispensaries can be located. And to my understanding, there's only one open. There may be 2, but there's one in Wiley that has opened. In Idaho, Wyoming, South Dakota, Kansas, Tennessee, Alabama, South Carolina, there is no exceptions, no provisions, no decriminalization. So my whole point is that it does vary by state. But what if I told you this? Federal government considers cannabis to be a Schedule I drug. What does that mean? That means that it is illegal to possess for any reason and is prosecutable. That having any of it is a violation of federal law. Having large amounts of it is a huge violation of federal law. So here you have Nevada, California, Colorado, where you have dispensaries. And so the question is, could the federal government come in and shut down a dispensary in Nevada, California, Washington, Oregon, Alaska, or Hawaii? And the answer is, if we look at the Supremacy Clause, yeah, they could. They could. So how are they still open? You know that the dispensaries cannot, and I said Hawaii, that's Alaska. Hawaii is mixed. How in the world can you have a law, a state law, that directly defies a federal law? Well, there's where it comes in. There's where the Madelynism, see? That's where that Madelynism comes in. It's not unconstitutional until the federal government, till the Supreme Court says that it's unconstitutional. The federal government has not sued even one state and said, hey, your law is a violation of federal law. It's unconstitutional. So we have this precarious relationship where there have been many reports over the years of federal agents, DEA agents, going in and closing down dispensaries, of arresting people that had prescriptions, of and you know that none of the dispensaries can deposit their money in federal banks because it's not legal. That money is not legal. I don't know what they do about paying taxes, but they have to, most of them deal in cash only, or they deposit their money with state banks or savings and loans. And those have to be state savings and loans, not nationally insured savings and loans. And so, I mean, I guess if the federal government ever decided, if the Attorney General ever decided that he was going to file suit against the state for violating the Supremacy Clause, they would have a very short hearing. The attorney for the United States, U.S. Attorney, would just say, Your Honor, the Supremacy Clause. And the judge would say, yep, you're right. Next case. But, I mean, who wants to be the president that is president at the time when you shut down all the dispensaries in the country and get them declared to be a violation of federal law? Probably nobody. No, I can't think of anybody. One more provision that we're going to look at and examine the primary document of, and that is the 10th Amendment. The 10th Amendment says, that's the whole thing right there. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. That means that if it's not in Article 1, Section 8, or somewhere else in the Constitution, and it's not specifically given to the federal government, or it's not in Article 1, Section 10 on that very short list of things that states can't do, the power is a state power. If it's not explicitly given, then it is a state power. And states conveniently forget that or to the people part, but it's a state power. So that means that federal government is technically restricted to only passing laws on those 17 things. And that is their job. Everything else is a state power. That is the reserve clause of the Constitution. So in summary, we have discussed several parts of the United States Constitution, we have talked about the fact that Article 1, Section 8 outlines 17 powers. That is the largest outlay of powers in the Constitution, and those are given to the United States Congress. Article 1, Section 8 also has the necessary and proper clause that gives them the power to pass laws that are necessary and proper. Those are implied powers, are not specifically written. There are powers that are prohibited to states in Article 1, Section 10. They can't coin money or have nobility or enter into treaties or declare war. Then Article 4 outlines things that states have to do. There we find the full faith and credit clause. You have to recognize the laws or judicial proceedings of another state. The privileges and immunities clause that requires you to give the privileges and immunities of your state to anyone, regardless of whether or not they are a citizen of your state, and the extradition clause that requires you to return a fugitive to the state where there is a warrant for their arrest. That's in Article 4. Then we looked at Article 6, where we find the supremacy clause. The supremacy clause says that in a conflict, national law, national constitution, and national treaties will prevail, and that just gives you a tiebreaker. The federal government and the laws of the federal government are the supreme law of the land. Finally, we looked at the 10th Amendment, and the 10th Amendment explains that if it's not specifically given to the federal government or specifically prohibited to the state, then it is a state power. It's a state power.